No, we would not have authority as this board to accept ownership of that basin. That would have to be dealt with at the municipal level. And in the past, they have not been accepting ownerships of basin other than the one.
Frank, if I might, first of all, we don't want ownership of any more basins. Speak to the board. And you talked about being of a benefit to the residents. Right now, on probably every third meeting, we have residents come in and complaining about that basin. It's probably the worst decision that this township has ever made to take possession of that basin for $40,000 that we have, because it's caused us nothing but problems. I call Scarborough all the time for this new developer, I guess, and Janet Crossley, is that her signature applicant here? He's our secretary. Same developers, if I might ask, is that who's going to do this extension development? And Ryan Home?
Not necessarily, no.
Is Scarborough going to be the developer?
Oh, no, not right now. Actually, this is Gulfwood LLC, which is a different, separate LLC from Carney's Point LLC.
Carney's Point LLC is Kevin Scarborough?
Yes, it is.
And signature of applicant is Janet Crossley?
Right.
They were the two previous ones that were
That's right.
first developed.
Yes, but not necessarily it's going to be the end.
Frank, in all due respect, when they put in the first development in Lakeview, the residents were complaining continuously. And you're probably not aware of that. Continuously complaining about roadways and mud and dirt, trucks coming down the wrong way. And we complained to them constantly, but their performance was so bad on the first development that we had to shut things down for a while. They ran pumps when they weren't supposed to run pumps. Now, Jenny, you're going to correct me if we go. Does that mean for since they're the same group, maybe not per se exactly the same, but it's pretty much the same group that put in the first development. They brought in fill dirt that they weren't supposed to bring in. They brought in 6 inches of fill dirt or so forth that they weren't supposed to bring in. Which, by the way, according to DEP, killed that endangered tree because you're supposed to put it up right at the drip line, and you didn't. You filled up against it and killed that tree.
Well, the dilemma, Mr. Mayor, is that this project has to be evaluated on its own.
I understand that.
And
I think the developer, Jen, if we're talking about the same developer and doing this, I think his performance of what he did in the past should come into consideration.
It does in terms of...
We're not obligated, correct it as we go now, I want to make sure we're right, that if his performance was so bad in the beginning, the first development, is that a reason to turn down any kind of variances or anything else also right now? That's the question I want to ask you.
The blanket answer to that is no.
Okay.
That what the law expects you to do is evaluate the evidence and the testimony that comes in on the new application individually. And if you have a history with that developer, you attempt to control the behavior or to moderate the behavior by additional conditions that you attach. And by making him produce evidence satisfactory to you that this design for this project is going to address the concerns.
Okay.
So you're wiser as you review the new application. You have to always remember that from a planning board perspective, enforcement is the obligation of the township. So what happens is, when a development is approved, if the developer is going outside the limits of his approval, bringing in fill dirt, doing things he's not permitted to do, it's the township's authority at that point to shut the job down. And the township has to, when you have a developer who you know needs to be watched, you have to be aggressively watching him. And the best thing a planning board can do is attach conditions to the approval and to do a careful and detailed evaluation as the plan and the evidence comes in to address those concerns.
Okay, and I understand what you're saying, that his performance was so bad in the first one that I would be reluctant to go ahead and vote for something for him to do again, but knowing that I have to, since what if we have already ongoing problems with this current developer, such as this basin that Mr. Hurst is talking about, that at least once out of every 2 meetings, we have residents coming in where the aerators never work. We have 3 aerators out there, we're lucky that any three ever work at any given
Let
time.
me
So
backtrack a
the
little.
same thing, if he's gonna pump in more water in that basin, and we're having problems with that, and, you know, it hasn't been resolved yet.
Okay, let me back up and correct just one thing that you said.
Uh,
The fact that you don't have to approve an approval, but what you do have to do is evaluate each application independently
Okay.
on its own merits. Now, if you have if this application includes, let's say, for example, aerators in the basin, and you have a history with this developer that their installation of that feature is not good enough, it doesn't work, then you can require as much evidence, as much testimony, as much information as you need and your professionals need to assure themselves that the way it's supposed to be installed will work. And then it's an enforcement issue. It's making sure that what you've approved is actually installed. Now, I will also caution you and all other members of this board, and I'm new to the board, but if you have a prior experience with a particular applicant such that you do not feel that you can impartially evaluate an application, you have to be careful in that you remember when you serve on an application, you serve as a trier of fact. And if your bias will not permit you to be impartial, you really should recuse yourself. So just you have to it's an individual decision for each and every board member, and I do caution you to evaluate your own mind and your own heart when you make those decisions.
John, I got a quick question. I mean, just as a education, what happens to the performance bonds and so forth?
The reason for a performance bond is so when you have problems like this on an application, the township can pool the performance bond and use the money to correct the problem. You'll also have a maintenance bond posted, so that if the applicant gets beyond the 2-year performance period and then the problems arise, you have an additional maintenance bond that you can pool. In real life, a township never wants to pool bonds because they don't want the task or the obligation of having to do the repairs. But you should have enough money set aside that the township, if they had to, if the developer is not stepping up to the plate, if he's gone bankrupt or he's just a turnip basically, you should have enough money set aside that the township can go in and rectify the situation based on bonds. Most reputable most reputable developers do not want you to pool their bonds because it makes it very difficult for them to get bonds for additional jobs in the future. The dilemma is sometimes you deal with people who aren't good builders and who are not honest men. I'm not saying this applicant is that, I'm just saying every township runs into that situation from time to time.
Mr. Chairman, can I just address one thing to the mayor? I think you'll find that if you check through the bonds, as I said, the developer, this is Richard Pearson. It was not Mr. Scarborough. Mr. Pearson did the site work on this project and bonded the project that you're talking about, and Ryan Homes built the homes. Now, Mr. Scarborough did, through one of his LLCs, made the application, got all the approvals. But I think that's what you're going to find, and that although you're calling Mr. Scarborough's office and he's trying to push his contractor, that in fact these bonds are in the name of Richard Pearson. And I think that, and you should check that and call that, but I think that's the case.
And in fact, if that's the case, that probably is an error, because generally as a rule, if the home developer is coming in and picking up the application, he either has to replace the bonds or post new bonds under his own name. Pearson would not be an appropriate individual to be bonding this improvement at this point. It should be Ryan Homes, or whoever built the ultimate
This is an interesting thing, that Ryan bought developed lots, bought the lots fully improved, so that there was a bond to do the work, the site work. The site work was bonded by Pearson, who did that, and then Ryan Homes bought the lots fully improved. The problem is some of the dirt came in from Ryan, some of it may have come in from Pearson. All the different things happened by different parties. I can tell you, Mr. Scarborough did not do any of it because he didn't either build the homes or do the site improvements. So we can figure out who shot John, but I think to get some results, the person who wants to get off the bond is Pearson, and that's where the pressure should be
Not
applied.
to dispute that, Ed, but the township committee received a request for a bond release from Janet Cross of